Thank you everyone for joining us today for this webinar, Identifying Human Rights Act 2019 Cases. My name's Carly Hansen. I'm the Sector Sustainability Coordinator at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, they are the Turrbal and the Yagara people. I wish to pay respect to their elders, past, present and future, and acknowledge the very important role that Aboriginal and Torres Strait Islander people continue to play in our society. As today's webinar is being viewed by people throughout the state and the country, and we've got our presenter up in Townsville, I'd also like to pay respect to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians listening in today. So today we are fortunate to be joined by Bill Mitchell, the Principal Solicitor at Townsville Community Law, and he'll be talking to us about the Human Rights Act and some questions that arise for CLCs under that Act, including how community legal centres might be able to identify relevant cases arising under the Act, what CLCs should be looking for in order to check whether the Act is engaged, and whether there are any effective ways of screening clients, recording and telling their stories. So I'll let Bill tell a little bit about himself in a moment. But firstly, I'd just like to let you know that today's session is being recorded and we'll have the recording available to download later today. The PowerPoints have been distributed to everyone who registered as of yesterday afternoon, but if you are popping in at the last minute, you can grab those from the handout section of the GoToWebinar control panel and download those to your desktop. We'll take questions at the end as we usually do, just to ensure a smooth running of today's session. So you can type your question in at any time and we'll read that out at the end. So there are two ways you can ask the questions. You can type those into the question box on the GoToWebinar control panel and we'll read those out as I've mentioned, or you can press the button that looks like a hand and we can unmute you if you've got a microphone and you can ask your question verbally. So I'll now hand over to Bill to take us through today's presentation, and I'll chat to you all again at the end of the session. Thanks, Bill.
Thanks very much, Carly. It's great to be here today. I presume that there's quite a few of us working from home, so if anyone hears a dog barking or a door closing or something like that, we'll just presume that it's one of those things that happens when you're working from home and not in your own office. Okay, so welcome today. We are talking about principally identifying Human Rights Act 2019 cases. Much of the material I cover today will be known to you already, but I'd like to just try and flesh out some ideas a little more around how we, and I mean we as lawyers or community lawyers or people in community legal centres, can identify these cases when they arise. Can I also give my own personal acknowledgement to the traditional custodians of the land? Here I pay my respects to the Wulgurukaba and Bindal peoples, and I extend my respect to any Aboriginal and Torres Strait Islander people who are present on the webinar here today. There's a disclaimer for you. I don't think I need to tell any of you that this isn't legal advice. I've tried to be as current as possible, and the last part of what I talk about will be very current because we'll be trying to flesh out some of the issues that we might see or are already seeing around the coronavirus and the manifestations of that in public policy. So look, we're here for a number of reasons today, but let's just run through a few of them first so we know and set the scene. The Human Rights Act in Queensland commenced on the 1st of January this year. And it says very clearly in section 11 that all individuals in Queensland have human rights. Importantly, and I think this can be lost in the maelstrom of what we talk about, that these human rights are in addition to our existing rights. It's very important to keep that in mind. It's also incredibly important that lawyers and advocates understand that they have an obligation to advise their clients about these issues. And so recognising when and how human rights are engaged is absolutely critical. We're not going to talk too much today about taking steps to protect human rights. This presentation is principally focused on recognising the sorts of issues that arise that might tell you that you've got a human rights case in front of you. Just also to set the scene, I think it's very important to note that our professional context is that the Australian Solicitors Conduct Rules, for those of whom in the webinar that applies to, and there are similar rules for other professionals, including barristers and social workers, a professional must always act in the best interests of their client, and that includes acting competently and diligently. And these professional rules are an important background because I believe that advising your clients about the impact of the Human Rights Act in their case is an ancillary matter that you are expected to cover in your advice to the client. So you are expected to act in the best interests of the client and be competent and diligent by turning your mind to the Human Rights Act in addition to any of the other matters that the client is raising with you. So let's just always keep this in the back of our minds that this isn't an opt-in situation where we might think about these issues as an addition. They are an essential part of any advice you provide to any client who comes and sees you. So it's a fundamental consideration for all lawyers in Queensland. I say that because really our obligation to act in a client's best interests and to be competent and diligent is just the flip side of being negligent or unprofessional. And it's really critical that we recognise that if we don't give someone competent advice about the Act and its implications, we may have ignored our professional obligations, and that could lead, in a worst case scenario, to the client losing some rights. It could lead to a complaint of a conduct nature being made to the Legal Services Commission. And in reality, what it leads to is a lessening of the impact of the Act. The Act's principal application is to try and change culture within Queensland and change a culture to one that respects and promotes human rights. And so our obligation is a very important one. We're not only acting in our clients' best interests, but we're actually acting in our community's best interests when we turn our mind to these issues. There are three principal ways that we will achieve the Human Rights Act's objects. I've listed them there, and they are straight from the Act, and that is requiring public entities to act and make decisions that are compatible with human rights, but also ensuring that courts and tribunals interpret the law in a way that is consistent with human rights. And if I can, just as a late entry, direct people's attention to the Queensland Human Rights Commission's website. If you go to the section on that website that has links to the interventions they have made in court proceedings, you'll see there are already some submissions made by the Human Rights Commission as an intervener, where they are telling the courts and tribunals how the Act ought to be interpreted. And so this is already happening. So it is worth your while making yourself aware of what's on that website, so you can not only see the information about the complaints process, but also the information about how the Commission itself is intervening in processes to make sure that statutory construction is consistent with the Act. And thirdly, through human rights complaints. And this is and I'm referring here to the formal complaints process. But in reality, these three things will never occur unless you are able to recognise that the Act is engaged. So we cannot achieve the objects until we all, as practitioners, recognise when the Act is engaged and when we can do something in respect of a client's matter. These are really your main takeaways today. And you won't get all the information today that gets you across all of these issues, but these are really the big ticket items that you need to be aware of as a practitioner that will be expected of you in recognising when the Act is engaged and then taking the further step of protecting the human rights of the client. Firstly, recognising when human rights are actually involved. This is critical. There are 23 human rights in the Act. It's quite startling when I speak to people who are lawyers, who are probably human rights lawyers, who still don't have a good understanding of the 23 rights in the Act. So the very first thing you should do is go away after this webinar, have another look back at those 23 rights in the Act, go to the other material that's available, such as the Queensland Human Rights Commission's fact sheets and the information for legal professionals, and familiarise yourself with what those rights are, but more importantly, the breadth and scope of those rights. The second thing we need to do to be successful in engaging with the Act is to recognise a public entity. And there are various definitions in the Act, and it is not a straightforward matter. So we're going to talk a bit about that. Thirdly, and possibly more importantly, is recognising public entity conduct, which might bring itself within the purview of the Act. Again, this is not straightforward, but we'll talk a bit about acting and making a decision or failing to consider things. Fourthly, recognising relevant court proceedings. And this is also very important because you may well have matters that are already on foot that engage with the Human Rights Act. And I'll give you one example where it's going to come up all the time, and that is in QCAT. So for example, if you have a QCAT matter which arises under a blue card refusal, let's say the blue card refusal occurred within this calendar year, both the Blue Card Services decision needs to be compatible with the Act, as does QCAT's consideration of the way it approaches the case. And so we need to be aware of the way that the Human Rights Act works in a dialogue form with both the courts and tribunals, in the laws they interpret, but in the way they act themselves. And we'll talk a bit about that later on. And then lastly, and probably one of the hardest areas to get your head around, is the issues of compatibility and proportionality. And these two concepts are absolutely inherent in the way the Act requires public entities to conduct themselves, and it really is the test. Well, I guess you could say it's where the rubber meets the road, and so we do have to have a firm understanding of what is meant by compatibility and proportionality. You can see old Sherlock over on the right-hand side there, who says there's nothing more deceptive than an obvious fact. And I say this because I think finding human rights cases or identifying cases does involve some detective work on your part. You do need to concentrate on the facts and details in each case that comes before you. And that starts from the moment the client contacts you. So what the client says to your intake workers or your reception workers or your administrative support workers, or you, the lawyer, if you speak to them first, is critically important. That's the starting point at which you can identify a Human Rights Act case. It's also critically important that whoever is taking the initial instructions from a client gets accurate lead-in information. And I mean, when I say that, I mean the sorts of information that might go into triage in class for those who work in CLCs, or just the appointment details that are put in a lawyer's diary. So if the other party, for example, is a government agency or a public entity, then it's critical to have that included in the appointment details. So from the very start and from the very lead-in, we are aware this might be a Human Rights Act case, and we can approach it from that perspective. Of course, we've got to consider the client's documents. This is also critical. And this is a bit of a gimme, really, in many ways, because the client will bring to you letters that they have received from the other party. And the other party might be very clearly a public entity. It could be a government agency that's writing to the person about some right or entitlement they have. But looking at the client's documents are just another part of the story. So you do need to dig a little around in the client's case in order to identify whether there's a Human Rights Act issue at stake. For us as lawyers, it's a critical time when we're getting instructions in the interview, and we really need to think about locating those critical points, such as the date the decision was made, who made the decision, and I'm going to talk about a methodology that you can use a bit later on. I think it's important to develop screening questions, but I think it's also important to think about who is your client group and what sorts of screening questions will work for them. If you're working in a prison setting with prisoners or families of prisoners, then the sorts of questions you have will be different to those if you're working with older people in the community, or perhaps young people who are coming in contact with the youth justice system. Think about how your agency can develop some questions or some conversations that you can have with people that will help you identify cases. It's a good thing to do with your staff team. You can brainstorm this, and after you've had this presentation, you might be able to use some of the material there to think about What can we do in our workplace that will allow us to better recognise these cases when they pop up? I'm like everybody else, and sometimes we just can't see the forest for the trees. It's incredibly important to make sure we look at the human rights angle first, and we must be methodical each and every time. I think it's fair to say that if we are proactive and methodical, over time it will become intuitive. And even now I'll be talking to a client and I'll be thinking to myself, oh boy, there's a human rights case issue there, which I might not have noticed right at the start. But in my own practice, I'm trying very hard to make sure I ask myself right at the start of every client interaction, and that could be an existing client or a new client, I ask myself, is there a Human Rights Act issue involved here? Just turning your mind to it, being methodical about that process. And I think over time, we'll just become intuitive about that, and we won't miss the cases that we should have seen. There's a little poem there by Rudyard Kipling. He says, I keep 6 honest serving men. They taught me all I knew. Their names are what and why and when and how and where and who. This comes from what's called the elements of circumstance, and it's been used since classical antiquity by some famous people you can see listed there. It's an information gathering or a problem solving process, often used by journalists or investigators. I think it's really important because it gives us a simple and easy to remember methodology through which we can look at the human rights issues that might arise in a case before us. And I'm going to use this as our methodology today. It's not the only methodology that you can use. There are many different sorts of methods that will work. But this is one, and I guess we need to start thinking about, in our own places, in our own practices, what sorts of processes or methods can we adapt or can we use that fit our needs and fit our clients' needs? And this is just one. So we're going to use this one today just as an example. The WHO is clearly the public entity. You can see the fabulous current Doctor Who on the right-hand side. Who is such an important question, because if we don't ask that question first, then we really don't know if we're dealing with a public entity. When I say who, it's really the other party or the related party involved in the client situation. I mean, you need to be familiar with sections 9 and 10 of the Act. You do need to get your understanding up to speed about how they work. But there are some easy ones here. So if we said, for example, the word Queensland as a prefix or suffix is a good place to start. The Queensland Ambulance Service, Legal Aid Queensland, these places are public entities. If we use words like public or agency or service or public servant or authority, now these may not be the sort of words that your clients use. They may use other words, and I don't want to get too bogged down in which words are key words, but they might say it's a bureaucrat, or they might say it's an officer. But there are clearly many types of words that should give you a clue that you're dealing with a public entity, that the WHO is a public entity. Obviously, if it has the word government in there, that's very important because that's a bit of a no-brainer. Of course, we also need to understand that some government agencies are outside the jurisdiction of the Act, and that includes those that are not defined in. So things like the federal government's agencies generally would not be covered. There are some examples where they might be included, where the state government is operating something that has generally a federal flavour. Let's stop there for a moment and say there's an example of aged care. So the Queensland government operates a range of aged care facilities in Queensland. And it's highly likely, I would think, that those agencies would fall within the ambit of the Human Rights Act, even if all those other ones, which are federally funded and operated through a range of agencies, are not covered. But those that are provided by the state government would probably be included. Similarly, you've got local government often uses the term officer, environmental officers, local laws officers, public officers, these sorts of terms. These are all big clues that you've got a WHO that is a public entity. So always your first step is to say, who are we dealing with here, and is that WHO a public entity? There are two sorts of public entities. Now, you do need to understand the difference between them, but we don't need to talk about that today in too much detail. I do want to raise that, of course, there are core public entities and functional public entities. And functional public entities are the ones that are probably a little trickier to see. Core public entities are those that we will notice immediately. They're the ones that are listed in the Act, or they fall within another reference group such as the public service legislation, which I'll show you in a moment. But remember that the who are public entities includes courts and tribunals acting in an administrative capacity. And it's very important that you understand the extent of that provision. And there are some cases there I've drawn your attention to. Patrick's case is an important one to read. These are Victorian cases, and we will have our own cases shortly. And we already have some of them, which I'll run through at the end. But it's important that you understand that not every action of a court or a tribunal is a judicial action. Many of the things they do are administrative actions. For example, the refusal of a court to provide an interpreting service for someone who has language issues, or the requirements for hearing interpreting or similar, that would be the court or tribunal acting in an administrative capacity. And so those actions will be caught by the Act. So this is really important to understand the distinction between these two things. And so don't just discard courts and tribunals because they appear to be judicial bodies. They are judicial bodies, but they also act administratively. So please go away and read those cases. I know they're quite complicated, those cases, but they are really a good way of getting your skills and knowledge around this issue up to speed. That is the administrative capacity issue. The inclusion of functional public entities is not something new. This is reflected in all of the other laws that we have in other jurisdictions here in Australia. But it's really aimed at making sure that public entities include those non-government organisations or private companies that are engaged to deliver services to the public on behalf of the government or another public entity. And there's an example there. This comes straight from the explanatory note, this text. There's an example there of a private company managing a prison or a non-government organisation providing public housing. And if you look at the Victorian decisions, and in fact, if you look at the decisions from the United Kingdom, such as Metro West and Sudi, you'll see that non-government housing providers are a clear example of being caught in most cases. And if you look at the reasoning behind those sorts of cases, they give you some insight into the test that's applied by the courts. Of course, we're going to have to see how our own courts approach these issues. However, just because an agency is a private company or is a non-government entity, that is just a clue that you need to look further into their operations against the tests in section 9 and 10. There are a number of things to be considered when we're looking at whether it's a public function, and there's a list there which shows the things that weigh towards it being a public function, and that it's conferred by statute, or it's connected or identified with government, or it's a regulatory nature, or that it's publicly funded, which is a big catch-all really. But these factors are not exhaustive, and really they don't determine whether an entity is exercising public functions. They are really matters to be considered by you when considering whether or not a person may have a complaint under the Act against that agency, or that entity, I should say. Again, these are factors from the Act itself, and we're not going to get bogged down in them because this is stuff you're going to have to read, you're going to have to understand, and you're going to have to apply yourselves. There are some functions of a public nature that are listed, and they include public education, including tertiary and vocational. And here's an interesting example. What is meant by vocational education is not clear at all. I think that if you look at the UNESCO's various documents about how vocational education, in fact all sorts of education, is defined, tertiary and vocational education will cover most forms of education. So don't think of public education as just being about schools. It's clearly broader than that. Emergency services, public health services, public disability services, public transport, housing and corrective services. These are all functions of a public nature. And these are all functions that you should be aware that might enliven the Act through the agency being a public entity. Section 9 also tells us to look at the Public Service Act, and in fact, that gives you a definition of a government entity. It's quite a detailed definition, but looking at that, I think you'd be hard pressed to find a government agency that was not covered by the Human Rights Act. It includes departments or parts of departments, public service officers and officers, agencies, authorities, commissions. It's a very wide-ranging definition. It also includes registries of courts and I presume tribunals as well. So this is another area where we need to think about a person's interactions with a court or tribunal. It might well be a Human Rights Act issue if those interactions relate to their experience with a registry or another administrative office of a court. So let's keep in mind that the application of the Act is very broad, and when in other places such as Victoria, the courts have come to look at the application of the Act, they say this Act is meant to have wide impact, and so they will read and they will construe these provisions very broadly. And so the exercise taken by a court is not to define down, but probably to construe it much more openly than we might expect. The what, the when and the where is really critical, because this is about the conduct of the public entity. What was the decision that was made or is going to be made? When did that become effective? And this is clearly important for our time limits for complaints to the Human Rights Commission. And there's a number of time limits there. And I'm not going to get stuck in the detail of how they operate with each other, but just be aware that there are time limits in the Act. And so us recognising Human Rights Act cases is not only critical for the client's rights, but if we don't actually get it correct, we might miss a time limit, which is a big issue for lawyers. So what is the decision being made? When was it made, or is it effective? And where was it made? And you might find that sometimes you're a little unsure about jurisdiction, and the where is part of that jurisdictional issue. For example, it's a clear one that if the decision is made in Canberra by an agency in Canberra, it's probably not going to be a public entity under the Act. So it does give you some clear ideas, but we shouldn't just presume. We should actually be turning our mind to these issues when we're looking at the conduct, I should say. The how is also really, this is the machinery provisions of the Act that says when a public entity is going to act or make decisions, they must be compatible and they must give due consideration to relevant human rights. The how includes a couple of things. It includes some exceptions, so the application of statutory provisions, and we'll see one a little bit later for QCAT where the residential tenancies legislation was used to in this sense. We've got the in accordance with the religious doctrine, and I haven't looked to see what cases throw up about that issue, but that's clearly one that's a live debate within our community and within the legal profession at the moment, or where an act was of a private nature. This is another important one that we need to be aware of. But so the how does include some things that are exceptions. The how must, however, consider relevant rights and consider compatibility. So the public entity must identify relevant rights and consider compatibility if there's no exception. So the lion's share of decisions made by public entities are required to identify relevant rights and consider compatibility. And that leads us to the why, and that is the why a decision is taken. And that is purely about two issues, compatibility firstly, and then proportionality. Compatibility with human rights is a unifying concept under the Act, and it is generally consistently drafted in the Act, and so we can apply the same kind of test each time we look at that principle. Compatibility means it doesn't limit a human right or that any limitation is reasonable and justifiable. You're going to need to come to terms with the test in section 8 in this regard, which then sends you on to section 13 for the detail. The proportionality test at section 13 has a range of factors, and it is a balancing act. It's not a clearly or easily accessible balancing act, but there certainly is some detail there about how proportionality should be decided. Now, the two cases there I've listed are big, chunky, complex cases. Momcilovic, which is our own Australian case in the High Court, and Oakes, which is a Canadian Supreme Court case. They both give so much detail about proportionality, I wouldn't expect you to come out the other side and say, well, I understand that perfectly. And we will have our own cases, and we need to have our own cases because of the way our Act is drafted to understand exactly how that works here in Queensland. But I think they're good starting points, and I think they're also cases that warrant some reading, so you can see some of the tensions around how proportionality has been applied or might be applied. In Oakes, this is the Canadian case. They set out this. The majority set out this test. It says measures must be fair and not arbitrary, and carefully designed to achieve the objective in question, and rationally connected to that objective. They should impair the right in question as little as possible. And lastly, there must be proportionality between the effects of the limiting measure and the objective. And so it's a scalable effect. The more serious the effects, the more important the objective must be. And we're seeing that right now in terms of coronavirus measures, where if we were to put the proportionality test against those measures, we would see the test in Oakes borne out very neatly. Please don't forget that human rights are intersectional. The intersectionality of rights is another critical thing that you have to understand, particularly where the improvement of one right facilitates the advancement of others and where human rights are enablers or multiplier rights. For example, access to justice. Let's just take those three that are listed there: education, health, and access to justice. For a young person who's denied education on the basis of a disability, they need to have their right to access to justice enabled in order to facilitate their right to education. And so we have to understand that these rights don't exist in a vacuum or in isolation, and that some rights, such as, well, not only the ones listed, but some rights facilitate the access to other rights. And so start thinking about how, when you look at the human rights in the Act, how they relate to each other, how they depend on each other, and how they coalesce in your client's situations. Never be shy to catalogue more than less rights when you're looking at the potential breaches in a human rights case. You might over time whittle down the ones that actually have application, but I think in these early stages of our looking at the Act, we should be brave and we should be cataloguing as many rights as arise in each situation. There's some key words people might use, and this is a tough one to think about, but equality in section 15. These words, recognition as a person, discrimination, equal, protection, these things aren't necessarily the sorts of things clients will say to you. But when you look at the words of section 15, you can see that there's a very strong theme about recognition of equality and without discrimination. You do need to think laterally about these cases, and if you look at Guyton's case in the UK, it was about the right to continue living arrangements after the death of a same-sex partner. Similarly, I would say Nick Toonan's case, which was raised under privacy laws, which was about the abolition of Australia's sodomy, or abolition of Tasmania's sodomy laws under a privacy right. And the issue that pops up won't necessarily look like the right that needs to be protected. So we do need to understand the text of the rights and the breadth of them just to know when they arise. Again, Guyton and Mendoza is a good case to read if you want to see how the UK has applied the various human rights tests. Although certain judges in Momcilovic went away from that approach to statutory construction, but it's a good case to read. These pigeons are obviously using language that your clients might not use. When we're talking about autonomy, I mean, there are clearly other words for autonomy. And as I said, your client may not approach you and say, this decision doesn't allow me self-determination and self-government. So we need to be listening for the words that clients use. And I'm not going to try and articulate those because I think there's some value judgments in that. And I think they probably differ depending on who they are, their generation, their level of education, the sort of legal issues they're experiencing. There are many varied things that will tell you, I should say, will alter how a client might describe their rights to you. But just be on the lookout for different things that describe the rights in the Act. I spoke earlier about the Human Rights Act being subject to other provisions, and the Horizon Housing Company and Ross case shows that the Act is subject to provisions such as the lawful eviction provisions in the Residential Tenancies and Rooming Accommodation Act. And I don't want to go into detail about that case, but again, it's worth looking at just so you can understand that there are some lawful limitations to the Act, and they're starting to be applied already. ADI is a more complicated case where a magistrate dismissed an application to vary a protection order, and the matter was on appeal to the District Court, and the applicant was seeking a stay. The court considered the human rights issues that were engaged and listed them there, but refused the stay. And I think it's one that's worth reading to see how the court will consider the Human Rights Act issues that are engaged in the lower courts. Again, there's not many of these cases. There's only 3 or 4 of them. So, but we're already starting to see them come up. And of course, you can find this out very easily. You've got all of the technology to go to a particular provision of the Act and use any of the Note Up resources and find out where it's been applied and how it's been applied. So you need to start thinking about doing that as well. This is a Victorian case, but I've listed it because I think it's important to reinforce that in one situation, a number of agencies might well be public entities. And in this case, it was an exemption application made about conducting women-only swimming sessions. And in that case, the City Council and the private entity that was running the pool for the council, as well as VCAT, who was hearing the exemption application, were all public authorities for the purpose of the Act. And so this is a bit like that, making sure we can see the forest for the trees. We need to always ask ourselves, in the span of the case and all the parties involved, are human rights obligations owed by the decision maker? And are they also required to be made by the decision maker on appeal or review? And this is particularly important when you're looking at internal review cases or IDR style cases within government. Obviously, we're dealing with some quite extreme situations at the moment. And Boris Johnson, the British Prime Minister, made this statement about the inalienable freeborn right of people to go to the pub. It was characterised very differently by Angela Merkel, who spoke about the right of freedom of travel and movement being hard-won rights, but restrictions are justified when they are absolutely necessary. And I've reproduced section 19 there under that quote from the Chancellor, and that gives you a sense of just how we might start thinking about what the Act looks like and how it might be restricted and whether that's a proportional restriction. Every single one of these things on the right hand, this social distancing, isolation and quarantine, all have human rights implications, different and related. And I had a rough count there and I listed the sections engaged by government social distancing, isolation and quarantine policies. Look at the number of sections engaged just by that, albeit an incredibly wide and, in many cases, brutal and possibly necessary policy. There's some excellent work being done by the Community Legal Centre sector already, and I shout out to Caxton Legal Centre for their pamphlets on the impact of COVID-19 or coronavirus on the legal system. This stuff is happening all over the place. There is work being done by all sorts of agencies about how people's legal rights are being impacted by the current situation. And there was an excellent press release went out for the Coalition of the Human Rights of Imprisoned People, which talked about the impacts on imprisoned people. You can find that if you just do a quick Google search. But yeah, prison welfare and advocacy groups say suspending family visits will cause distress. People who are in prison who don't need, there's issues, prisoners and those who are immunocompromised. These are all human rights issues. Similarly, we've got Economic Justice Australia, who were formerly known as the Social Security Rights Network, talking about gaps in coverage, the impact of mutual obligation, the need for increased advocacy funding, and impacts on the service system, which we're seeing all over the news this morning, with people not being able to access payments that they need to survive in this current environment. I've listed in the presentation some of the rights which are very obviously engaged by this current situation, which is likely to continue for some time. And you can look at those at your leisure. And these are not all of them. This is just a very quick analysis. And Human Rights Watch itself has said that we need to protect free expression and ensure access to critical information. This is very important. We need to ensure that quarantines, lockdowns and travel bans comply with norms. We clearly need to protect people in custody and in other institutions, including those institutions in the community, such as group homes and other places where there might be a higher risk or a more vulnerable population of people. We clearly need to ensure the protection of healthy workers, and marginal populations are very, very much at risk, and we've seen a lot of measures to try and keep the virus out of the Northern Territory for those vulnerable populations of Aboriginal and Torres Strait Islander persons. But even promoting access to water and sanitation. We've all been joking about the access to hand wash and toilet paper. These are basic human rights. We also need to be thinking about low wage workers. So that's Human Rights Watch's take on it so far. And that's all I had time for today, and I think I'm pretty much on time. So I'd be happy to take any questions, or we can go from there. Thanks.
Excellent. Thank you, Bill, for that thoughtful presentation. Some really, interesting questions and a good approach to looking at your clients' matters and assessing whether they do have any human rights implications. So we'll take questions now. Just as a reminder, there are two ways you can ask questions. You can type those into the question box on the GoToWebinar control panel, which is probably the easiest way to ask your question, but we'd also be happy to take questions verbally if you do have access to a microphone. So Bill, a couple of questions have already come through, so I'll start with Alu from Caxton. Bill, are there any examples of cases where human rights have been raised as a defence or in interlocutory applications?
I would say the case of ADI is an example of that, because the district court was looking at the application of a stay. So it's very clear that it applies to interlocutory applications which might give rise to an administrative order. So yes, there are, and ADI is one of them, but there are many Victorian examples, and I don't have them to hand, but yes, there are lots and lots of examples of that. It's very important to look at the action the court or tribunal is going to take and ask yourself the question based on those decisions I referenced: is this an act of a judicial nature, or is this an act of some other nature? The courts have struck down essentially the notion that there are quasi-judicial decisions, and so yeah, it's a great question, and it's an area ripe for work for us, particularly when we're seeing people in discrete task assistance manner who may be coming to us on a piecemeal basis to look at steps in a process. And there may be examples such as an adjournment. That's not a straightforward example, but there may be parts where we say, now listen, the whole case might not raise human rights issues, but this part of it certainly does.
Okay, great. I've got another question from Karina. So where do universities fall under the definition of public entity?
Well, it's quite clear that universities that are established under statute within state law are public entities. And so, for example, James Cook University here in Townsville is established under the James Cook University Act, which is a Queensland law. Now, the extent to which their operations are subject to the Act, I don't know, but I think as a starting point, we'd say yes.
Okay, thank you. Faylene has asked, and this is a question that has come up many times already, but Bill, your thoughts would probably be appreciated also. Do you think the Act will eventually extend to private sector and non-government, not-for-profit organisations?
Well, I think the important thing to say is that it already applies to non-government organisations such as community legal centres. It already does apply to those agencies because they receive public funding. They are delivering services that are akin to government or are connected with or recognised or identified with. And they are established under statute. They are incorporated associations. So I think any agency that gets state government funding or is an incorporated association or provides services that might be identified with government, or all three of those things, ought to look at its situation because it's probably already a public entity, a functional public entity under the Act. If you want to go away and read a case about that, you can read Metro West and Sudi, and you can just Google that, you'll find it. It's a very well-known case. There are many other cases that cover that issue, but in respect of private entities, I don't think that it's likely in the near future that it will be opened up in that way. That would only happen in the statutory, that's something that will get raised in the statutory review process of the Act. I think what's more likely to see is we're more likely to see focus put on private arrangements where services are delivered. And the more remote you get in Queensland, the more likely the service that gets delivered will be delivered by a private entity and not a government agency itself. And so there is already a good deal of private entity work that falls within the Act. I guess us recognising that is the trick, but purely applying to private entity actions, I'm not sure. I think that's a long way off.
Excellent, thank you. And for people who are interested in that area, Community Legal Centres Queensland, together with Ben Schockman, did a presentation at the end of last year, which covers some of the implementation sort of requirements for specifically not-for-profit. So do check that out on our website under our human rights page. A couple more questions coming through. So Patricia's asked, does the right to understand English and be understood, does that involve a human right, or is that a human right?
It absolutely does. And this falls within the ambit of what's called communication rights. And there's some really excellent work being done on the right to communication in Australia. And this includes things far more broad than the use of interpreters. This applies to people being understood and having access to a range of communication assistance devices. The right to free expression does at its heart include a right to be understood. It's not just a right to speak, it's a right to have your speech understood and received and understood. So yes, the breadth of free expression rights are much, much greater than most people give them credit for. Most people simply say it's a right to say something. In fact, it's much more broadly a right to be understood. So that's a great question. And if that person wants to send me an email, I can send you a copy of a paper I've written for speech pathologists, or I can, Carly, I could get you to hang that up on the webinar page, where I cover off the issues around communication rights in some detail. But it's a fascinating area with very large numbers of people who are affected by communication impairment and disability.
Absolutely. That speech is already on our website, so you can just download that one now. Patricia's just asked a follow-up point. So if would not being assisted by a properly credentialed interpreter be a breach of the Act? In Queensland, language service providers are contracting untrained, non-credentialed interpreters who are making mistakes in communication in health, legal, education and other areas. Does this breach human rights if the interpreter is not properly qualified?
I'm going to take the careful answer and say that's probably legal advice that the organisation needs to take.
Yes.
And I think, but if I can answer it and say that's very much a proportionality issue. And so whether the decision to only use those interpreters was a breach of people's human rights would absolutely be a proportionality issue. I think that's a great example of one that I don't want to, nor do I have an easy answer to it, but it clearly involves balancing the factors in the Act.
Okay, great. Russell's made a comment or a question here as well. So clearly there's a note that indicates that private schools are not considered public entities, but do you think it's possible to construct an argument that private schools who are delivering education with public funding according to state government curricula are functional public entities?
I think there's a lot of people working on this issue at the moment, and I would say that there are some problems associated with focusing on using this when we already have a regime, albeit a flawed one, within the Anti-Discrimination Act. And I say it's flawed only because some of the exceptions that operate in these cases are problematic. And I think that let's just take the disability discrimination issue as a little microcosm of the bigger question he's asked. I think that Tamara Walsh and others' research shows that if you are a child with a disability, you are unlikely to get the education you need, and you are also unlikely to win a discrimination case that you bring. This is reflected in the work of the Special Rapporteur on Education for Children with Disability. Clearly, it's a huge issue, but I do think the right to education gives us a new area of potential test casework in answering this question. Again, I don't work in this area. There are many people who are working on it, and Russell probably knows the answer better than I do. So, but look, clearly this is an area where the Act is going to get some consideration, not too far away, I think.
Okay, hopefully that is helpful to you, Russell. Another question that's come through, so follow up from Faylene. She was probably thinking with her earlier question about not-for-profits of the local community tennis club or disability services that are NDIS funded. I think NDIS is specifically mentioned. Yep.
NDIS services are included in the Act as a public entity. So if you are an NDIS provider in Queensland, you are a public entity. You know, the tennis club depends a bit on how it's operating. And if you look at the Hobson's Bay case, where it was a local municipal swimming pool, you know, there's all sorts of different arrangements, but I wouldn't rule out the tennis club being a public entity depending on how it was funded and how it operated. And if it was like that case where it was a local government-owned tennis court that was operated by a private operator, then it may well be covered. The NDIS is almost certainly covered under the Act. I mean, they are covered under the Act, but again, the extent of that clause is not known because it hasn't been tested. But the starting point is that NDIS providers are covered under the Act.
All right, thank you. Is the Land Court a public entity when making a recommendation following a merits review?
I have absolutely no idea. I'm sorry, Alison. I don't know, but I think if you go to the Victorian Bench Book on the Charter of Rights and Responsibilities, and if you go to the section on who is a public authority and look at some of those cases around when courts and tribunals are acting judicially, that's probably a starting point. I just don't know. I'm not familiar with the Land Court's operations. So, I mean, I know basically, but not enough to comment in a way that would be authoritative.
Okay, no problems. So the last question that's come through, is there an argument that the Charter of Aged Care Rights includes the rights in the Human Rights Act for older people in Queensland?
I think the Aged Care Charter is, which is a standalone subordinate instrument to the Aged Care Act, is a woefully inadequate piece of legislation. It comes from a consumer rights perspective. It doesn't even reflect human rights as we know them. In Queensland, though, if your aged care facility is operated by the state government, then there's a very strong chance that it will be covered by the Act. Again, this hasn't been tested, but this is a point that's been talked about for some time. So I think it's a watch this space. I think you need to, if you have an aged care complaint, you need to look at who operates that facility. That's the who, that's the first question. You need to look at who operates that facility. And if it's in fact the state government, then chances are they owe human rights obligations to those residents. So yes, I know that's a bet each way, but I don't think I can give a more detailed answer at this stage. But it's a great question, thanks.
Okay. So there are a couple of people with hands up, so I'm just going to check in with you to see whether you've got a question and whether you've got a microphone. So firstly, Michael Overend, have you got a question? I can unmute you now if you'd like to ask your question.
No, I didn't have a question. So the glitch on the screen.
That's no problem. Thank you. And Peter Last, you've got your hand up as well. Do you have a question? I'll unmute you now if you'd like to ask your question.
Last from Ethnic Communities Council of Queensland. Just a massive thank you to Bill. That's been such great information, and appreciate your time. Thank you.
Thanks, Peter.
Thanks.
Okay, it sounds like that's, oh, no, one more hand has come up. Cecilia, I'll unmute you and you can ask your question if you like. Nope, no question there. Okay, that's fine. All right, if you do think of anything else, we're finishing exactly on time. Another thank you there from Faylene. Thanks to Caxton and to Bill. Hopefully Townsville as well. So thanks so much, Bill, on behalf of everyone who's listening today, and thank you everyone for all of your great questions. Certainly we'll be doing more work in the human rights area over the coming months as things do sort of unfold, and to look at some of the various, rather than sort of focusing exactly on each right, as we know they are all interconnected, we'll be looking at different groups of people that might be affected by the Act. Do check out our human rights page on the Community Legal Centres Queensland website, and all of the other great resources we've linked many of the other organisations who are doing good work in this area on our page as well. So I'll share that link with you when I send out the recording for today's session. But for now, thank you again, Bill. It's been great to chat to you and hear from you as an expert in this area. Hope everyone takes care and stays safe out there. Thank you.
Yeah, thanks for that. Bye.